Imagine this. A promoter group transfers more than 27% shareholding of a listed company. Control is indirectly shifted through multiple promoter entities. Regulation 3 of the SEBI Takeover Regulations gets triggered. Regulation 4, dealing with acquisition of control, gets triggered. Regulation 5, dealing with indirect acquisition, also gets triggered. Normally, this should lead to one major consequence: an open offer. But in this case, SEBI said no open offer required. Why? And more importantly, what conditions did SEBI impose before granting this exemption? Stay till the end because this order is extremely important for CS executive, CS professional, company secretaries, compliance officers, promoters, investment bankers, and anyone dealing with promoter family trusts. Today we are discussing SEBI's exemption order in the matter of Themis Medicare Limited involving Vivid Margi Trust. Before we begin, please like the video, subscribe to the channel, and share it with fellow securities law professionals. Let's understand the background. Themis Medicare Limited is a listed company on both NSE and BSE. The promoter group collectively held approximately 67.15% of the company's equity share capital before the proposed transaction. The promoter family proposed to create an irrevocable private family trust called Vivid Margi Trust. The trust was established primarily for succession planning and welfare of family members and future generations. Now here is where the issue begins. The trust proposed to directly acquire approximately 27.51% shareholding of Themis Medicare from existing promoters. Not only that, the trust would also indirectly acquire interest through promoter-controlled private companies holding shares in Themis Medicare. As soon as this proposal was examined, three crucial provisions of the SEBI Takeover Regulations came into play. First, Regulation 3. Regulation 3 requires an open offer when an acquirer crosses the prescribed shareholding threshold. Second, Regulation 4. Regulation 4 applies where control over a listed company is acquired. Third, Regulation 5. Regulation 5 deals with indirect acquisition of shares or control through another entity. Therefore, on the face of it, this transaction attracted Regulations 3, 4, and 5 and would ordinarily require an open offer. But the promoters approached SEBI seeking exemption. The key argument was simple. Nothing was changing economically. No outsider was entering. No third-party acquirer was taking control. The trust was merely becoming a holding vehicle for the same promoter family. The trustees and beneficiaries were all promoters, immediate relatives, or lineal descendants of the promoter family. Now comes the most important examination undertaken by SEBI. SEBI asked, is this trust merely a mirror image of the promoter family, or is it a mechanism through which effective control can be transferred? This distinction is critical. SEBI examined whether there would be any change in control, whether public shareholders would be affected, whether promoter shareholding would change, whether minimum public shareholding norms would continue to be satisfied, whether beneficiaries were genuine family members, whether the trust structure complied with the conditions specified in Chapter 8 of SEBI's Master Circular relating to family trusts. After examining the transaction, SEBI reached a significant conclusion. There would be no effective change in control. The promoter group would continue to remain the controlling group. Public shareholding would remain unchanged. The transaction was merely an internal family reorganization and succession planning exercise. Accordingly, SEBI granted exemption from Regulations 3, 4, and 5. This means The trust was exempted from making a mandatory open offer. But remember, the exemption was not unconditional. SEBI imposed several safeguards. The trust must continue complying with all conditions prescribed in the Takeover Regulations and SEBI Master Circular. Annual compliance confirmation must be maintained. The trust structure cannot be altered in a manner inconsistent with the exemption conditions. A post-acquisition report must be filed with SEBI. And importantly, the exemption is limited only to the open offer requirement. Compliance with insider trading regulations, LODR regulations, and other securities laws continues to apply. Now let's discuss the practical takeaway. This order reinforces a principle that every securities law student should remember. The Takeover Code is intended to protect public shareholders when there is a real acquisition of ownership or control. Where there is merely an internal transfer within the same promoter family through a genuine family trust and no effective change in control occurs, SEBI may grant exemption from the open offer requirement. However, such exemption is not automatic. Every trust structure must satisfy strict conditions prescribed by SEBI. For examinations, remember these keywords: family trust, mirror image test, no change in control, internal reorganization, succession planning, Regulation 3, Regulation 4, Regulation 5, open offer exemption. These concepts are highly relevant for CS professional securities laws, corporate restructuring, and practical compliance. Now I want your view. Do you think promoter family trusts should automatically receive exemption from open offer requirements? Or should SEBI continue examining every case individually? Write your answer in the comment section. If you found this analysis useful, subscribe to Corporate and Securities Law Compass. I will see you in the next video. Thank you. Disclaimer. Viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.